Thank you. Thanks, Daphne. Welcome back to Senate Education. It is Thursday, February 24th. Thanks, everyone, for jumping in. This is S219. Ms. Siglowski, you sent us a memo yesterday outlining some questions, some concerns you had and your team have. We have, as you have probably watched by now, yesterday we heard from Ledge Counsel outlining kind of a response to those concerns. And I just want to give you an opportunity to publicly just share your concerns and for us to have a conversation with our Ledge Counsel. And you've also had an opportunity to hear from our Ledge Counsel. So just wondering if there's any additional comments you have or anything you would like to share at this point.
Yes, thank you very much for asking us in on this topic. And thank you. We were able to listen to the conversation yesterday and wanted to thank the committee for the additional language that was added on page 3 of the bill, the highlighted language in version 5.5. And we do appreciate the committee's commitment to addressing anti-discrimination in this bill. We think that it lacks the necessary specificity and enforcement mechanisms that are required to really make it a complete package. And we believe the anti-discrimination requirements are critically important to be in the bill. I'm going to get to that in a minute, but also wanted to hit on the other accountability measures that should be included in the state's contracts with private schools. It would be important to include other basic requirements around things like curriculum, staff qualifications, open meetings and public records requirements.
Whoa, just a second. Sorry to interrupt. Is this in your memo or are you now talking about something else?
This is in the memo.
Okay, terrific. Thank you.
Yep. Fiscal accountability and student assessment. And I thought I would just add, this is not specifically in the memo, but it relates to what was in the memo, that the Act 1 working group is right now working on the education quality standards. And they're working on making those standards more supportive of diverse communities, more inclusive. And so it would make sense to include the requirement to comply with those education quality standards as part of the contract, for instance.
So now that is not in the memo. Is that accurate?
Right.
I'm just getting a little bit, in January, we heard you were very kind to come in, very brief memo saying that, this was your position, and now you have another position, and now it sounds like you're kind of going off of the memo. So I just, this is a very narrowly tailored bill to do certain things. And we have, so when you're going off of the memo, if you would just acknowledge that would be helpful.
Okay, I will. But I don't really consider it going off of the memo because the memo lists things that the contract we think should include. And I think the education quality standards could fit into those that list that we've included in the memo.
Okay.
So as to the anti-discrimination requirements themselves, the bill lacks clarity on which specific laws apply and how they apply. And one of the laws that we listed was the Equal Educational Opportunities Act. And I wanted to bring that up because that is a law that protects English language learners. And I know that's a topic that your committee has covered a lot lately. And it has requirements for serving those students by providing affirmative educational opportunities so that they can access curriculum and services equally. And so, for instance, it's not clear to us looking at this version of the bill that the schools, private schools that are receiving public funds are required to comply with the Equal Educational Opportunities Act, because there isn't a list, a readily available list of every single anti-discrimination law for the state of Vermont and federally. And I'm not clear whether this law falls under an anti-discrimination law or not.
Okay, thank you. Mr. Desmarais, would you mind responding? And you are muted, Jim.
Sorry. For the record, Jim Desmarais, that's counsel. So the language of the bill requires compliance with all federal and state anti-discrimination laws, and as they apply to public schools. So in terms of scope, it's all federal and state laws and discrimination laws. In terms of how, same degree as they apply to public schools. The law just mentioned is an anti-discrimination law. It's not listed individually, but it's one of those laws, so it would apply. You can list it if you want, but there are lots of probably other laws you could list too. So the purpose of the list that we have is just mentioning two laws, which is the Vermont Public Accommodations Act and the Equal Opportunity Act are listed. Sorry, the Unfair Labor Practices Act are listed because there are lots of questions raised as to whether those laws do apply to these schools. So we call them out for a reason. We haven't called out every anti-discrimination law. We can expand the list, but I believe it's already covered because it covers all federal and state anti-discrimination laws.
So it sounds like, so just to be clear, the language in the bill covers what Ms. Zaglowski and team are raising as an issue.
Yes. Yes.
Thank you very much. Okay, thank you. Committee, questions on that at this point? Okay, Ms. Zaglowski, the floor is yours.
Thank you very much. Another point that we made in the written testimony is that the bill does not specify who is protected by the non-discrimination provisions, and it's not made clear enough that all provisions of anti-discrimination laws apply. And also, it does not provide a robust enforcement mechanism by the state. And this is I think a really important part of our testimony. It doesn't address the applicability of the enforcement mechanisms that exist currently in state and federal anti-discrimination laws, but even probably more importantly, it doesn't provide any kind of a framework in the bill for how the law gets enforced. And with that, it's really incomplete. And I think, we have some new entities here in this bill. We have this relatively new entity of independent schools eligible to receive public funds, and then this new entity of a contract that's going to be used. So it would be important to have some type of a framework for how this is going to be enforced.
Would you mind going back to the second one before we get into enforcement? Would you mind, just so we can take these one at a time?
I'm not clear what you're asking.
So we just had talked about, it was something to do, and I apologize, I'm still pulling up the memo. You were concerned about discrimination with regard to students, faculty, staff.
Right. So I think what I heard yesterday from your committee discussion was that this bill is not designed to protect students or faculty and staff, that it's really designed for the independent school approval process. But that if someone,
I don't know what that you're talking about whatsoever, actually. Mr. Desmarais, would you say a few words about the second part of the memo as it relates to the discrimination?
Well, the orientation of this bill in terms of enforcement, there are provisions in current law that grant authorities to the State Board of Education to revoke approved status for schools or to revoke the eligibility to receive public tuition. So if the schools violate current law or rules, the State Board has authority to revoke their approved status or their ability to get public funds. So that's the enforcement mechanism. Basically, it's a State Board process, and this whole bill is oriented toward a State Board approval process. So it doesn't give independent rights of individuals to sue. That would be a different orientation of the bill, if you will. You might have to go actually and amend the underlying anti-discrimination laws to provide further avenues of remedy for individuals. I don't know about that because that's not my wheelhouse, but this bill was never drafted or oriented that way. It was always oriented toward a process of requiring the State Board to take action when a school does not comply.
And with regard, yes, Senator Persley.
I think you were just going to ask the same question for Jim. That their concern is that it was unclear who it applies to, the anti-discrimination laws, but it seems like it would just apply to everyone that the anti-discrimination laws apply to.
Correct. Yeah. But whether that gives them a private right of action to sue based on this bill, that's a bit of a different question. Yeah.
But in your mind, Jim, there's not an unclarity of to whom these anti-discrimination laws apply.
No, they would apply to employees, to students, to the same extent as public schools.
Mr. Pawlowski.
Yeah,
please.
Sorry.
No, please.
Isn't the question though, if it applies to them, but they can't do anything about it, if it happens to them, is that a concern?
Yes, please, Senator Persley and Senator Lyons.
They could do something about it. They would go to the board and say that the school's right to take public money should be revoked. That would be their redress.
Senator Lyons.
No, I was going to say they'd go to the board.
Okay. Ms. Siglowski, anything else?
I think one concern.
Fannin.
For the record,
Ms.
Jeff
Siglowski
Fannin.
has the floor. It looked like she
Oh,
had
I'm sorry.
unmuted. No, it's okay.
I'm happy to cede the floor to Mr.
Okay.
Fannin for the moment.
All
I
right.
needed to look for what I was looking for, so thank you.
Okay, thanks. Mr. Fannin.
Sorry.
No problem.
So one additional concern we have is, for example, in this regard is out of state and out of country schools. So we seem to have a dual process, and if that's the case, we just want some clarity. We don't want to add to the confusion. So if the process is they go to the state board, we think that enforcement process ought to be mapped out a little bit more clearly in the bill. And just to put a fine point on it, so that there is clarity, so that if it's a parent who's being discriminated against, perhaps that they do enjoy the benefit or the right to go to the state board to complain. And what does that process look like? Same for a student and that sort of thing. And that's the concern. We want clarity in this. We appreciate the good work you've done here to try to address this. And we're trying to get at it a little bit. This is a new construct. The contract construct that we're talking about here is brand new. And we think it's what Professor Black talked about. Great that.
Right,
that
I
we're-
think he was the one who may have helped lead us in this direction.
Correct. And I think we're just trying to put some meat on the bones here to make sure that that it meets all of our needs and protects.
Mr. Demarais, is there need for meat on the bones here? Can you just help us out in terms of, it sounds like we're looking to you as our legal counsel around lack of, concerns about lack of clarity, et cetera.
Well, there are a number of state board requirements and statutory requirements for an approved independent school to be approved today, much less expanding it to what we're doing now. So, for example, if they don't offer the correct courses of study, if they don't have proper health and safety, if they don't have trained staff, there are lots of reasons why currently a school could be approval could be revoked. So for any of those things, including this new thing, somebody could go to the state board and say, hey, the school's not complying with these requirements, and bring it to their attention, and then they'll decide whether to take action or not. There's no process now for, like in statute, for individual complaints going to the state board. However, people obviously can raise issues to the state board as a public body, and I assume they'll respond. So you could add process here. I'm not sure what the process would be, other than to say that people could raise concerns, but they can do that, I think, already. So you could formalize something if you want to, but it's not so different than every other condition that there is in statute and rule now that could be raised with the state board.
Mr. Fannin.
So the one can, so to expand on that, Jim, I appreciate that, is the use, I think, on pages 3, 19, 22, and 24 of reasonable efforts. And I don't think that's defined. And that's the kind of clarity we seek. What is reasonable efforts? One person's reasonable efforts may look very different than another's. And that's the type of clarity we are striving to get to. We think that's ambiguous, and it's going to invite problems, not solve problems.
Yeah, that determination is left to the state board in terms of how they would interpret that. And reasonable efforts is commonly used in statute and not defined, because often it's very fact and circumstance oriented, and courts have a way of looking at that. So you could try to define, but I'm not sure how in statute. I think, yeah, so you're correct, that's not defined.
Committee. Questions for witnesses, comments, or questions for Ledge Counsel at this point? Okay, I will leave it to, I think, Ms. Siglowski, did you have anything else? I didn't want to cut you off.
No.
Okay. Mr. Fannin?
I would just add, the concept of other, we've talked here about non-discrimination laws, and that's great. Are there other laws that should apply that apply to public schools? So, for example, FOIA requests or your public records requests, financial disclosures, and perhaps the state auditor has issued some reports on private schools, and should the auditor have direct oversight? There's a lot of state money here at issue, and the state auditor, I think, currently lacks that specific oversight, and that probably should be added to the bill.
So it would have been great had you come maybe 3-4 weeks ago. Your first memo, as you may recall, that you two signed off on, said, I reviewed it last night. You want to come in once and you want to say your piece, and that was it. Completely respect that, but also really respect the continued dialogue. This is a very narrowly tailored bill, as you know. What I don't want it to do, and I don't think the corner office wants it to become, is a vehicle for everything else at this point, especially at this point in the game. I think you want to, as much as we're respecting having you in at this late stage. I think you also respect that it is late, without a doubt, and we want to be able to move something sooner rather than later.
Right. And I respect that. I think the one, our first memo was, we thought you should hold off and take a pause. And so certainly the non-discrimination stuff has become bigger, and we're weighing in on that, and think that's
Sure. And I think, if I may, I feel like, we know that dollars are going to religious schools right now. And so we need to put some guardrails around that, and we want to protect the students and staff. And I appreciate that when these kinds of things go. I know I've heard from my predecessor that Act 173 and the agreements around those kinds of things were challenging. And I recognize not everybody's going to be on the same page with some of these things, but what we're trying to do is a pretty narrow, tailored bill to address a couple of issues that we have that have been raised to us by members of the community. Okay, Senator Hooker, please.
Thank you. Thank you, Chair Campion. This is a Senate bill.
Yeah.
It will go to the House. And is there room for your concerns to be presented there?
Mr. Fannin.
The obvious answer, Senator Hooker, is yes, I think.
Okay, thanks.
Committee, any other questions at this point? Okay. Mr. Demaray, thank you for weighing in. Very much appreciate it. Mr. Fannin, Ms. Pawlowski, thank you both for representing your team. Also want to thank everybody for weighing in on mascots, and as well as miscellaneous ed, both of which we moved earlier this afternoon. Okay, committee, I think we have, seeing no other business today, any other questions or comments, committee, in terms of other issues? Senator Lyons, S-197, do we want to, shall I ask Ms. McLinn to take us through that tomorrow?
Possibly. I have met with the Department of Mental Health, and they're going to be recommending some changes that I think will improve the bill. It doesn't hurt to go through the bill as it currently stands. We can do that. Yep. And then, but know that there probably will be some changes that our committee makes, and your committee will be able to, this committee will be able to spruce it up as well as needed.
Okay.
So, yeah.
All right, maybe you and I can chat about that
Yep.
a little bit. Daphne, I think you can take us offline. I think